Mr. Dela, we're supposed to have started shortly after you left my chambers. It's almost an hour now.
Yes.
What was the problem?
Yes, my lord. My lord, when I was about to trying to convene the court officials, I got a request from the stenographer and said that Mr. Topperman asked that may the matter be adjourned until the 11:30 because he has to deal to talk with his clients. And she also asked her to go and inform the judge about the matter. So that was why we delayed calling.
I confirm that.
Thank you, sir. Mr. Dela?
My Lord,
Oh, sorry.
I would like to address you. My Lord, regrettably, I have been now burdened with yet another very difficult task in this matter.
Ngelishwa ke ndiphinde ndaxwayiswa uxanduva olunye olunzima apha kweli tyala.
And that is to apply on behalf of accused 1 and 2.
Kokokuba ndenze isicelo esigameni sikamangalelo kuqala nesibini.
On their instructions, you
Malo
to recuse yourself from this matter.
okokuba wena urhoxe ekulichopheleni eli tyala.
And unfortunately, I'm going to have to place certain remarks that your Lordship made in this case under scrutiny.
Ngelishwa kuzawunyanzeleka ukuba iintetho ezithile zenziwe yile nkundla ndizihlabe amadlala.
And I'm going to have to request your Lordship to examine your Lordship's own remarks.
Ndizacela inkundla ukuba ihlalutye intetho eyenzileyo.
Just
Perhaps my Lord French indicate whether I have served the application papers on him. Perhaps he'd like to indicate whether he opposes the application or whether he needs further time to deal with it. I apologize on that.
Now, ndinikile ke amaxwebhu malunga nesi sicelo ugxa wam ofundileyo ndiyazi nokuba ufuna okokuba awaqwalasele ngoku apha kwenkundla okanye mhlawumbi ufuna elinye ixesha.
sorry, I'm not ready to interject my anything like that. I was going to ask the court to first deal with what made us to adjourn that order first, and then this second part now, the second part of applying for your recusal, my lord, should be dealt after that. What made us to adjourn first, and that was what I was going to suggest.
Yes, I think he's just responded by confirming what you were saying.
Okay.
That he approached the stenographer and then my secretary to convey the message that he needed to consult with his clients.
And also about that issue of the state of my representing team trying to help actually 2 and 3 when they are coming to court, that they will they have undertaken to do so.
Yes.
And they have
that is the police.
Yes, my lord.
Okay.
So that was the order. I was just gonna also be made an order that the IO will supply his number to Mr. Topperman. Then if they approach the court, they can phone him straight. Yes.
Yes, I think that's what we agreed in chambers.
Then.
Yes, it is so ordered that the accused number 2 and 3, whenever they want to come to court, they should liaise with the investigating officer. Can do so either via your counsel, that is Mr. Topperman, or directly deal with the IO.
Bendiqwenela
Thank you
basiqwalasele
for bringing that to my attention, Mr.
As a court, please, my lord.
lamba besithe sawusingatha apha obangele okokuba siqumame isicelo ibe seso kokuba umangalelwa wesibini nalo wesithathu xa beza enkundleni kundla yenze umyalelo okokuba mabaxulumane nomphandityala ngqo okanye ngegqwetha labo.
As I was mentioning to your Lordship is going to have the exceedingly difficult task of objectively or trying to objectively consider your Lordship's own remarks.
I think I know the test. I'll deal with it.
Thank you, Lord. Might I hand the application papers to your Lordship?
Thank you, sir.
Thank you. My Lord, so the notice of motion indicates that accused 1 and 2, the first and the second applicants, seek your recusal from the matter. There is a founding affidavit by the first applicant, accused number 1, in support of the application, and I propose to take your Lordship through the affidavit. He says the following: I, the undersigned Timothy Omotoso, Yaba State, under oath, I am a major male and the first applicant herein. The facts contained in this affidavit are, unless otherwise stated or it appears otherwise from the context, within my personal knowledge and to the best of my belief, both true and correct. I am presently on trial together with the second applicant herein before the Honourable Mr. Justice Makawula in the above mentioned case. I am accused number 1 in the case, Mrs. Lusando Solani. The second applicant is accused number 2 in the case. All references herein after are to what has transpired in the case. The case is partly heard before the Honourable Mr. Justice Makawula and has been postponed until 22 October 2018 for further hearing. One state witness, namely Ms. Cheryl Zondi, has testified on behalf of the state thus far. She is still under cross-examination by my attorney, Mr. Peter Doberman. Mr. Peter Doberman is also representing both my accused. For reasons which are not relevant to this application, Ms. Zondi has been excused from attending court for the time being, and I'm advised the evidence of another state witness is due to be interposed commencing on 22 October 2018. Ms. Zondi is the complainant in counts 19 to 20. On 17 October 2018, shortly before postponing the case until 22 October 2018 and excusing Ms. Zondi from attending court for the time being, the Honourable Presiding Judge addressed Ms. Zondi in the following terms while she was still on the witness stand. Court, regarding your exams, on behalf of the court, we wish you all the luck. You must pass your exams. Thank you. That is your future. You have to concentrate on your future and forget about what is happening here. It will take its own course. Thank you, Your Worship. You are not doing this for yourself that is coming to this court. It is not about yourself. It is about justice. Yes, Your Worship. So leave everything to us and then go and write your exams and concentration on your examination. Thank you, Your Worship. Good luck. Thank you. The deponent goes on. My perception is that in making the comments highlighted in bold above, 1. The Honourable Presiding Judge has already made up his mind and found that Ms. Zondi has come to court to testify not for herself, but as a crusader in a quest for justice. 2. The Honourable Presiding Judge is overtly sympathetic towards Ms. Zondi and her cause. 3. The Honourable Presiding Judge has openly identified and aligned himself with Ms. Zondi's cause. 4. The Honourable Presiding Judge has already decided that Ms. Zondi's version is true and accepted same without hearing all the evidence or argument. 5. The Honourable Presiding Judge has already decided to mete out justice on behalf of Ms. Zondi. 6. The Honourable Presiding Judge has already decided to convict and sentence me and the second applicant. 7. The Honourable Presiding Judge is biased in favour of Ms. Zondi and the prosecution. 8. The Honourable Presiding Judge is prejudiced against me and the second applicant. 9. The Honourable Presiding Judge is and will not be impartial. And 10. I and the second applicant will, in the circumstances, not receive a fair trial before the Honourable Presiding Judge. In my belief and respectful submission, the said comments by the Honourable Presiding Judge presuppose an ultimate outcome favourable to Ms. Zondi and admit of no reasonable interpretation other than that which I have placed thereon. In my respectful submission, the Honourable Presiding Judge has unfortunately and in the circumstances disqualified himself from continuing to preside over the matter. I only seek a fair trial before an impartial judge and justice. I do not make this application lightly. I know that my trial is likely to be delayed by the replacement of the presiding judge, and since I'm in custody awaiting trial, that I will be prejudiced thereby. In the circumstances, I respectfully apply for the Honourable Mr. Justice Makahula to recuse himself. Signed under oath, Timothy Omotoso. The second applicant's affidavit is in the same vein, my Lord. She says in her affidavit that she has read the founding affidavit by accused number 1 and that she
Confirms it.
she has the same perception. So I'm not going to take your Lordship through that. And then, my Lord, since these papers were drafted today, your Lordship made certain remarks this morning, in fact. And one of those remarks was that the accused must be given an opportunity to prove their innocence in this case. That can only mean that in your Lordship's eyes they are presumed to be guilty at this stage. Otherwise they would not have to be given an opportunity to prove their innocence. But that is not the main point that I rely on. The accused, applicants 1 and 2, do rely on that and have expressed their outrage at that comment, that it should even be suggested that they might be required to prove their innocence. I want to refer your Lordship immediately to the test for recusal, and it is very well set out in the Mulordzi decision. This is Mulordzi, spelled M-U-L-A-U-D-Z-I versus Old Mutual Assurance Company, South Africa Limited, 2017 ZASCA 88, which was delivered on the 6th of June 2017. This decision is available online, my Lord. This is a decision of 5 judges of the 6th of June 2017, my Lord. This is a decision by no less than 5 esteemed judges of the Supreme Court of Appeal, where they refer in paragraphs 46 to 48 to the applicable legal principles.
Again, Mr. You say it's a
ZASCA, my Lord.
Yes.
88.
88.
Yes, 6 June 2017.
Yes, thank you. Paragraphs 46 to 48.
46 to 48. The facts are not relevant, my Lord. The case concerned whether His Lordship, Mr. Justice Mhlophe, in the Cape, ought to have entertained the matter. But I'm not going to go into the facts of the case. They're not relevant to the present matter. But what is relevant is the law. And those judges expressed or set out the principles that apply as follows. And I'm going to read from paragraph 46 and following. It is settled law that not only actual bias, but also the appearance of bias disqualifies a judicial officer from presiding or continuing to preside over judicial proceedings. The disqualification is so complete that continuing to preside after recusal should have occurred renders the further proceedings a nullity. So, if your Lordship were to refuse to recuse yourself now, today, and another court were to find that you should have recused yourself, the entire proceedings would have to be set aside and the trial would have to start de novo before another judge. The general principles are well established. They are now enshrined in section 165 in brackets 2 of the Constitution, which provides the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favour or prejudice. Thus, a judicial officer who sits on a case in which he or she should not be sitting because seen objectively, either he or she is actually biased or there exists a reasonable apprehension that he or she might be biased, acts in a manner that is inconsistent with the Constitution. S versus Lagrange puts the position thus. A cornerstone of the legal system is the impartial adjudication of disputes which came before our courts and tribunals. which come before our courts and tribunals. What the law requires is not only that a judicial officer must conduct the trial open-mindedly, impartially and fairly, but that such conduct must be manifest to all those who are concerned in the trial and its outcome. The right to a fair trial is now entrenched in our Constitution. The fairness of a trial would clearly be under threat if a court does not apply the law and assess the facts of the case impartially and without fear, favour or prejudice. The requirement that justice must not only be done but also be seen to be done has been recognised as lying at the heart of the right to a fair trial. It must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial. The integrity of the justice system is anchored in the impartiality of the judiciary. As a matter of policy, it is important that the public should have confidence in the courts. Upon this social order and security depend. Fairness and impartiality must be both subjectively present and objectively demonstrated to the informed and reasonable observer. Impartiality can be described, perhaps somewhat inexactly, as a state of mind in which the adjudicator is disinterested in the outcome and is open to persuasion by the evidence and submissions. In contrast, bias denotes a state of mind that is in some way predisposed to a particular result or that is closed with regard to particular issues. Bias in the sense of judicial bias has been said to mean a departure from the standard of even-handed justice which the law requires from those who occupy judicial office. In common usage, bias describes a leaning inclination, bent or predisposition towards one side or another, or a particular result. In its application to legal proceedings, it represents a predisposition to decide an issue or cause in a certain way that does not leave the judicial mind perfectly open to conviction. Bias is a condition or state of mind which sways judgment and renders a judicial officer unable to exercise his or her functions impartially in a particular case. Notwithstanding that a judge's own insights into human nature will play a role in credibility findings or factual determinations, judges must make those determinations only after being open to and giving proper consideration to the views of the parties before them. The reasonable person, through whose eyes the apprehension of bias is assessed, expects judges to undertake an open-minded, carefully considered and dispassionately deliberate investigation of the complicated reality of each case before them. In the end, the only guarantee of impartiality on the part of the courts is conspicuous impartiality. An apprehension of bias may arise from an association or interest a judicial officer has with or in one of the litigants or in the outcome of the case. It may also arise from conduct or utterances by a judicial officer prior to or during proceedings. There is as well what has been described as prejudgment, which means that a decision may have been made or an opinion formed most often unfavourable about a person or issue before knowing or examining the facts. In all these situations, the judicial officer must ordinarily recuse himself or herself. The test for recusal adopted by the Constitutional Court is whether there is a reasonable apprehension of bias in the mind of a reasonable litigant in possession of all the relevant facts, that a judicial officer might not bring an impartial and unprejudiced mind to bear on the resolution of the dispute before the court. In Sarfu 2, paragraph 48, the Constitutional Court formulated the approach to an application for recusal as follows. It follows from the foregoing that the correct approach to this application for the recusal of members of this court is objective, and the onus of establishing it rests upon the applicant. The question is whether a reasonable, objective and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. That is, a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favour and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse himself, herself or himself if there are reasonable grounds on the part of a litigant for apprehending that the judicial officer, for whatever reasons, was not or will not be impartial. And that is the end of my quotation from that case, my Lord. So clearly, my Lord, the test in this application is entirely objective. The applicants do not have to demonstrate actual bias on your Lordship's part. A reasonable apprehension of bias is sufficient to require your Lordship to recuse your Lordship. Now, what I suspect happened, my Lord, is that you in fact allowed your humanity to get the better of you, my Lord, when you made those comments to the witness. And unfortunately, I have to criticize you for doing that, my Lord. In effect, what your Lordship said, or what your Lordship did, was to commend the witness for coming to court to testify in the interest of justice. And you went further than that and you said, leave it to us, my Lord. And that can only mean leave it to me. And it can only mean leave it to me to see that justice is done on your behalf. Now, my Lord, to say to a witness,
just a minute, sorry to interrupt. Who constitutes the court?
you do.
And then I'm me alone.
Yes.
Thank you.
And to say to a witness in the terms you did, you coming to testify is not about yourself. It's about the interest of justice. Presupposes of necessity that the witness is here to tell the truth and has been telling the truth. Clearly that must be the case. Because a witness who comes to court to tell lies and mislead the court cannot be here to do so in the interest of justice. Quite clearly, my Lord. So, the inescapable conclusion, my Lord, in the eyes of any reasonable person, is that you in fact commended the witness for coming to court to tell the truth in the interests of justice. That's what happened. You commended her for testifying. You wished her luck with her examinations, and I don't have any quarrel with that. There's nothing wrong with that, my Lord. Nothing wrong with that. That was perfectly in order. But that's not all that you said, my Lord, unfortunately. You were clearly overtly sympathetic towards her, my Lord. And you openly, with respect, you openly aligned yourself with her cause. And I understand what happened, my Lord. But with respect, it's not your job to console witnesses. That is somebody else's job. Your job is to listen to the evidence dispassionately. A judge cannot display even the slightest hint of bias, my Lord. Your remarks can only mean one thing, my Lord. You presupposed an outcome when the process is not yet complete. You have already accepted her version. Unfortunately, my lord, the damage has been done already. You can't qualify your remarks now. You have to deal with this application on the basis of what you said at the time. So, on any reasonable interpretation of your remarks, my lord, you've already made up your mind to accept the evidence of Ms. Zondi. And as far as the applicants are concerned, there is no point in this trial continuing before you. And I pause to mention, my lord, as the applicants have said, they don't seek to gain anything really from bringing this application. There's no ulterior motive on their part to ask you to recuse yourself. They're going to be prejudiced. Their trial is going to have to start day over before another judge. When is that? We don't know when another judge will become available. Accused number one is in custody. He's going to be prejudiced, my lord. He says all he's asking is for a fair trial before another judge. This is not a tactical maneuver of some kind to try and get rid of you. That's not what's happening here. Now, my lord, insofar as your position is concerned, you're going to have to think very long and hard before you refuse this application. And your lordship has to look to the possible consequences of not making the correct decision. If you grant the application, yes, Ms. Zondi will have to testify again before another judge when the trial starts day over. And that is most unfortunate, that she will have to go through possibly what she has already gone through for another time. But if you were to refuse this application, my lord, and the other 20 complainants come to court and testify, and they have to go through the traumatic experience of appearing here and relating what they say happened to them, and another court will ultimately to find that you should have recused yourself in the first place, it will mean that all of those women will have to come and testify again, which will be far worse than were your lordship rather to err on the side of caution and to recuse yourself now at this early stage. So those are in essence my submissions, and of course the decision is your lordship's to make, and I trust that your lordship will come to the correct conclusion on the facts that are before you. Those are my submissions. Thank you.
Thank you, Mr. Doberman. Mr. Ndelo, and your response?
Indeed, my lord, I have some submissions to make. My lord, an application for the recusal of a judge raises a crucial matter. And my lord, the Constitutional Court have already formulated the approach to the recusal of a judge. In this case, in the case of the President of the Republic of South Africa versus the South African Rugby Football Union, the selection is as follows: 1999, Volume 4, SA at page 147. It is a constitutional court. The approach that came from that regime was as follows. I quote: the question is page 1%, but the paragraph I'm quoting from is paragraph 48 of the judgment. At the court head, the question is whether a reasonable, objective, and informed person would, on the record, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case, that is a mind open to persuasion by the evidence and the submissions of the counsel. Now, what are the grounds now brought by the defense? Is that on the words used by my lord when the court was wishing the witness good luck for her examination and asking her to please not think about or taking this trial to the exam room. Was that enough to suggest that the court will not listen to the submissions that made later to us in this case? It is my submission that matters, that not the case. If really the test from the case, I got it that on a reasonable and objective and informed person, that those words really were specifically to wish her luck and not to take this testimony and the trauma of the courtroom to the exam room. Therefore, it is my submission that Madam Defendant has failed to make a ground for this court to recuse himself as a court reason.
I shall take time to consider this application. The time is 12:15. We'll resume at 1:45.
As a court, please.
The application itself and then consider the submissions we made.
Thank you.
All right.
We show people's manners.
Carefully for bringing those cases. My hands are so easy to find.
There. We can, I can stand here.
What time did it come for us? Let's go outside.
Hello? Yes. Nompu, okay. Stand by. Yeah, we can speak about it behind me. I'll move out of shot.
It's fine. I mean, if you need
I'll walk out of shot, then you can show. I'll speak about Nompur, then you pan to Simpiwetana. Pan to Simpiwetana as well. Yeah, I'm going to pan that whole round. Flip it. Can't see. I'm latched. Stand by. Good afternoon, Nompu. I think a lot of people were very shocked when Doberman pulled that ace up his sleeve, asking Judge Mandela Makahula to recuse himself and basically saying that the judge has been very biased towards the co-accused Zukiswa Sito Lusando Solani, as well as the first accused Timothy Omotoso, and saying that the way in which he handled the Zondi testimony when she was being cross-examined, it just showed that he was biased towards them. Also, with regards to his remarks and utterances, saying that Zondi should go write her examinations, she should not worry about what's happening in court and leave it up to him, leave it up to the court to make that decision. So all of that came out, before we adjourned. I know that we're going to be resuming at 1:15 when the judge will give, his verdict, whether he will recuse himself or not. But Nompu, just to make mention of the fact that earlier this morning, trial started a bit later on today. We saw several of the ministers also arriving to sit in on proceedings, but we also saw the co-accused, Omotoso's co-accused, not present in court. And we heard Doberman saying that they were afraid to actually come to court. They were afraid for their lives. You would know that they were also, saying that they were manhandled outside of court last week Friday when some of the protesters in support of Zondi threw water bottles at them, and that is the reason why the trial started a little later today, because those co-accused were afraid to come to trial. But we also saw Doberman also coming out and saying that he was also manhandled. People were hurling insults at him like he was a rapist. People were asking him to leave this particular case, to step down, and he also pleaded with Judge Mandela Makahula to look into this, where we saw the judge actually saying that it was not in his jurisdiction to actually protect any of the co-accused and actually channel them to the civil courts, Nompu.
And then, Jade Lee, what about what happened over the weekend? There's a lot of confusion. Some people saying that Mr. Omotoso's church was closed down. Was it or wasn't it?
I think that is one of the things on everyone's lips. A lot of people, a lot of media also came out saying that the church was closed down. I can confirm that the church was provisionally closed after the congregants left the church building yesterday, but so far as it stands, the church is not permanently closed down. We spoke to the spokesperson of Nelson Mandela Municipality, Tubanzi Mniki, who has confirmed this. He also told us that the church falls in the ambit of Zone 1 in the CBD, and this means that any property in Zone 1 can run, whether it is at a church, whether it is a school or a private business, so it has not closed down, Nompu.
All right, Jadely, we'll wait for you to rebroadcast a bit later with the judge's verdict on whether he's going to stay or go. That was Jadely Posa reporting there from Port Elizabeth. We're going to have a
Thank you.
Jade, I'm asking you nicely to just move. Or asking you nicely to move a little bit so that I can just get into the crowd.